Welcome to In the Name of the Law, with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, Brandy Thompson from the Kronzek firm, and Mary Chartier from Chartier Nyamfukudza PLC. Now, let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law, a legal talk show about real legal problems.
In the name of CPS defense and family law.
We are here at In the Name of the Law with Brandy Thompson, a partner at the Kronzek Law Firm in Lansing, Michigan. And we're going to talk today about the Abuse and Neglect Central Registry. Brandy, welcome back. And can you tell us what is the Abuse and Neglect Central Registry?
Thank you, Lisa. Yes, a lot of people have not a clear understanding of what the Abuse and Neglect Central Registry really is, but it's actually an internal database that is held by the Michigan Department of Health and Human Services. It's not open to the public, but it can still have many consequences for someone who's placed on the registry. Different employers, specifically those that work with children, such as teachers, healthcare workers, bus drivers, therapists, and many more, can be prevented from participating or being employed in those particular areas if they are placed on the central registry. It also may prevent you from volunteering at your child's school or being a coach or otherwise participating in events with children at schools.
So why is a person put on the central registry?
When a person, specifically either a parent or a non-parent caregiver, has been substantiated, and that means that the Department of Health and Human Services through CPS has found by a preponderance of evidence that you are a high risk of potentially injuring or neglecting a child, they will place you on the central registry, on this abuse and neglect registry.
So you said potentially a risk. So does that mean you don't have to be charged with a crime or have an abuse and neglect petition filed against you?
You're absolutely right. There are a lot of people on the central registry who have never been charged with a crime, who have never had a petition for abuse and neglect filed against them by CPS, but they've been placed on this central registry. What happens is CPS, if they've received an allegation, if they've conducted their own internal investigation, and if they've found internally that they feel there's a preponderance of evidence that the allegations are true, they place you on the registry. There's no hearing, there's no quote unquote conviction, there's no adjudication by a judge or court of law. This is done specifically by the caseworker and their supervisor internally.
Okay, and so you said, you mentioned substantiated for abuse and neglect, and aren't there various degrees, levels of substantiation, and do all of them put you on the registry or just certain levels?
There are different levels of substantiation. How CPS puts someone on the registry, they will first determine whether or not there's a preponderance of the evidence to substantiate you for the allegations. And preponderance of the evidence, yes, it's basically 51% or just over 50%. It's a very low burden in the eyes of the law that they would have to come up with. And then they do this risk assessment in conjunction with that. And again, it's very discretionary with CPS. If they feel that you're at high risk and they've gone through and made that determination, you're on the list. There's no hearing, there's no overseer or judge. And in certain circumstances, even if they've done a risk assessment and you're at low risk, but the allegation is very serious, such as a serious injury to a child, serious physical injury to the child, or sexual abuse, they can do this override and place you on the registry anyways. There's a lot of ways that CPS and a lot of discretion for CPS to put you on that registry.
So since you said there's not a hearing, does the person know that they're being looked at before they get put on the registry? And then once they're put on the registry, how do they find out about it?
Technically, they are supposed to be notified via certified letter of placement on the registry. I come across many people who indicate that they have never been notified, they never received that letter. But the rule is you're supposed to receive a certified letter. Other times the caseworker will tell the parent or non-parent adult caregiver that they've been placed on the registry. The other way that you can find out if you're on the registry, if you suspect, you can ask MDHHS, Michigan Department of Health and Human Services, for a central registry clearance request. And that's simply going to DHS, giving your driver's license and filling out the form for the request. And then you can determine whether or not you're on the list.
Okay, so let's switch gears a little bit. Once you learn that you're on the registry, is there a way to get off of it? And is there a time limit to do that?
Yes, there absolutely is a process and a procedure for requesting expungement. Once you receive that letter, that certified letter, you have 180 days to start the process for expungement. The letter does provide directions for the person who's been on placement, but the first thing you would do is you would file a written request for expungement to that caseworker that has placed you on the registry. I can tell you, Lisa, with regard to my experience in these cases for well over a decade, I have never seen or heard of someone getting expunged at that point. They're supposed to be able to have that. That's the point of filing that request, but I've never seen it granted. It's always been denied. So the next step, which is the step where I usually come in, is requesting a hearing before an administrative law judge. And you then present witnesses, evidence. One important thing to remember is that the state CPS still bears the burden of proving to that administrative law judge that there is a preponderance of evidence to substantiate and that you do belong on the central registry. So the state will still bear the burden. Everybody can present evidence and witnesses on their behalf.
So this sounds like the point in the process where an individual might be well served by having an attorney if they don't already have one that's helping them on a matter.
Yes, that's correct. You're never required to have an attorney, but certainly unless you feel comfortable putting witnesses on the stand and cross-examining the state's witnesses, it's probably a good idea to go ahead and have an attorney present with you. If you have an attorney representing you and Assistant Attorney General will represent the Michigan Department of Health and Human Services on their side. If you choose to move forward without an attorney, CPS will represent themselves and they won't have an an Assistant Attorney General representing them.
You mentioned the fact that maybe some people don't receive their letters. So does that mean they have more time to request to get off the registry until they get the official certified letter?
Yes, absolutely. I mean, the rule is 180 days from the date of the service. Because the rule is that the letter has to be certified, there is an actual card with that for which the parent or non-parent caregiver would have to sign, and that is basically the start date. So if they don't have proof that they have given you that certified letter, that time doesn't essentially start running until you get that letter.
So let's talk about, in your experience, having done a lot of these central registry expungement cases, when you run through your hearing, you present evidence and documents and witnesses, what are the chances of getting a person off the registry? What's been your experience with that process?
My experience has been very good with this process. Again, because this is an internal type of assessment, very discretionary, and we're dealing with caseworkers, I've found that they don't always do a full assessment, really look at all of the facts and circumstances surrounding it, and they make a very snap judgment. And I think that the administrative law judges that preside over these hearings are very fair and really have a good idea of what it takes to get to that preponderance and what evidence is necessary in order to place somebody on the registry. So I think, it's a good idea to make that request if you've been placed on the central registry and give it a shot.
And if the administrative law judge denies the request, are there any other options?
Yes, you can appeal the decision, and worst case scenario, if you've not been removed, the vast majority of registry cases, there is an automatic removal after 10 years, except in some of the extreme circumstances. So you can still be removed even if the judge denies.
Well, thank you, Brandy.
In the Name of CPS Defense and Family Law is brought to you by the Kronzek firm. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
We often hear that we are entitled to no-fault benefits if we're injured in a Michigan motor vehicle accident. However, we may be wondering who pays those benefits. Is it the party that caused the accident? Do we turn to our own insurance company, or do we turn to someone else's insurance company? Today, we have personal injury attorney Steve Sinas from the Sinas Dramis law firm to help us better understand the answers to these questions. Steve, it's great to have you back.
It's great to be back. I welcome the opportunity to answer these important questions.
So if I'm in a crash, who pays for these things that we call no-fault benefits?
So let me quickly point out what's at stake. No-fault benefits can fund your medical care arising out of an accident. They can fund your income loss, and they can fund also certain household services you may need. So they're very important. And so the general rule is you look to your own policy. And when I say your own policy, it's not just a policy issued to you. It could be a policy issued to your spouse or to any relative you live with. And if there's a policy there, you typically claim benefits from that policy, but there are exceptions.
So what are those exceptions?
It's people injured in a motor vehicle accident, if they're on a motorcycle, people injured in an employer-owned vehicle, certain situations where you're injured in what's known as a vehicle for hire, and also in situations where there's just no insurance at all in the policies available, and there's a special rule that applies to those people.
So let's start with motorcycles. What's the rule for motorcyclists?
So a motorcyclist, even if they have their own auto insurance, will turn to the motor vehicle that's involved in the crash. And it's important to note, if you're a motorcyclist and there's no motor vehicle involved in how you crashed your motorcycle, you're not going to get no-fault benefits. There has to be a motor vehicle, meaning a car. And if so, you turn to the policy that insures that vehicle. If there's no policy on that vehicle, then you turn to your own policy. I'll just point out, under the reforms, not everyone has lifetime coverage anymore. So motorcyclists can be injured in a motor vehicle crash. They could have their own lifetime medical expense coverage on their no-fault policy, but since they turn to the policy of the vehicle involved, it could be a situation where that vehicle is not insured with a lifetime policy, and the motorcyclist is then subject to those limitations. It's unfair, but that's one of the realities for motorcyclists under the 2019 reforms.
Wow. Okay. So what is the rule for people who are injured in an employer-owned vehicle?
So it's important to note this rule applies to any situation where a person who's an employee of a company, it takes that vehicle, it's owned by the employer, and if they're injured or their spouse is injured in that car or any of their resident relatives, then all those people are going to claim benefits through the employer's no-fault policy and not turn to their own policy. And likewise, for these people, just like the motorcyclist, if the employer buys less than lifetime, then all those people are going to be subject to those limited amounts of coverage under the employer's policy. So this can be another situation where people can buy lifetime medical, but under the reforms, be forced to get it through a policy that doesn't provide them lifetime medical.
Okay. Well, what is the rule for people who are injured in a vehicle for hire? And I think by for hire, you mean like a taxi or a rental car?
The issue with this is that there's all kinds of different ways in which people can be injured in a vehicle that's somehow been paid for to use for transportation. And in terms of how you define it, whether it's a taxi, a bus, an Uber, a ride sharing vehicle, it matters. And so there is the general rule that in a lot of these situations, you will turn to your own policy, but based on the circumstances and based on the type of vehicle involved, it could be that you turn to the policy that applies to that vehicle. What I would say to people is that if they're ever injured in a situation involving a vehicle that somehow has been paid to use or to ride in, they need to look carefully at the law to figure out that they're claiming benefits from the right policy.
Wow. Okay. And can you submit claims to both policies?
You can, and sometimes you need to do that to make sure that you're covering your bases in the event there's any ambiguity. So
Okay.
you need to really think that through, and that's where maybe lawyers are needed to figure out vehicle for hire claims for you.
Absolutely. And what about people who are injured when they don't have any insurance?
If there's no insurance in the household, the typical rule is that you end up claiming benefits through the assigned claims plan, which is this unique entity that exists under our law that deals with the claims where people have the right to claim no-fault benefits, but there's no policy to claim those benefits under. So they turn to the assigned claims plan and it gets assigned to an insurance company to take over the claim, and they pay it as if it's their own claim. It's a unique aspect of our system, but that's how those people are treated.
And what happens if the accident occurs outside of the state of Michigan?
So in that situation, to try to sum this up in a relatively simple way, the way to look at it is that your no-fault insurance coverage, if you have it for yourself or anybody in your family that lives in the same household as you, is that it follows you wherever you go. And the no-fault law says your no-fault coverage follows you wherever you go in the United States, its territories, or Canada. So if you're injured in another country other than Canada, you're not going to be entitled to no-fault benefits. But if you're in a motor vehicle accident in Canada, anywhere in America, including its territories, which can include Puerto Rico or Guam, if you will, or the U.S. Marshall Islands, whatever it may be, if you're injured in a motor vehicle accident, you're going to get no-fault benefits, even if you're not in your vehicle that's insured with no-fault coverage.
So would that then apply to a rental car in Florida?
It would, and that's what is important for people to understand, is that when they go other places in America, even if they're walking down the street and they're hit by a motor vehicle, if they have a no-fault policy in their household, they're going to be able to claim benefits under that policy. There are some exceptions that can come up in certain situations. If you own another vehicle in another state, it can be a little more complicated. And then also, if you don't have your own no-fault policy or there's not one in your household, you do need to be in a vehicle insured with Michigan no-fault in an out-of-state crash to be entitled to benefits. So for those people who aren't in a household, they have a little different, or a household with no-fault coverage, they have a little bit different analysis. And they usually have to be injured in a Michigan motor vehicle insured with no-fault to be able to claim no-fault benefits for the out-of-state crash.
It sounds pretty complicated. It sounds like if you have an accident, you probably should be contacting an attorney to help you figure it out.
Yeah, you have to think through all this, and you only have a year to act and get in notifying the appropriate insurers. So you have to act quickly. So yes, you need to think it through and maybe talking to attorneys in your best interest.
So you said 1 year to file a notice?
Yes, you have 1 year to notify the appropriate insurance company of the fact that you're going to bring a claim for benefits. And if you don't notify within a year, then you could lose your right forever to claim benefits. So you have to think this through right away.
Thank you, Steve.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm. In the name of criminal defense.
Today, Mary Chartier, Takura Nyamfukudza, and I are honored to have State Representative Sarah Anthony with us. She's from the 68th District for the Michigan House and is here to talk about the issue of weapons in the state capitol. Now, the Michigan State Capitol Commission voted to ban open carry in the state capitol, which was a change from its prior position. Sarah, Representative Anthony, could you please tell us why there was that change?
First, thank you. Thank you for having me. It's always good to see you all and to be a part of this amazing show. I think for me, I believe the Capitol Commission saw what happened at our U.S. Capitol, and they felt that the tensions had reached a boiling point. Although for me, I think we as a state had reached that point much sooner. On April 30th, we saw an angry, violent mob storm our Capitol building, heavily armed, with the express purpose of inflicting violence, inciting fear, and intimidating lawmakers. And so I believed that the right moment the Capitol Commission should have acted was the next day, May 1st. And that's the day that I wrote a letter to the commission asking them to ban all firearms. And so since that day, I have been lifting up my voice, testifying, sending letters and emails, asking constituents across the state to do the same. And so the action earlier this month that the Capitol Commission took was a step in the right direction. Although, if I can be honest with you, I don't think it goes far enough. Knowing how tensions are so high right now, we're seeing state capitals as well as our US Capitol under siege across the country. And with tensions this high, I don't think we can afford to, meet these challenges halfway. I think we need to completely ban all firearms from the Michigan State Capitol, which is not an unprecedented move for government buildings. You all know this, right?
So I wanted to ask you, Representative Anthony, what's the logic? So we can't take weapons, concealed or otherwise, into a courthouse. We have to go through a scanner. We can't take them into an airport. There's all these places that we're not allowed to carry any weapons at all. What is the rationale? What could be the rationale to have any kind of weapons in a Capitol building where legislatures and the governor are doing their job of, creating laws for the people and enforcing the laws?
And you hit it right there, right? It's a unique workplace. Tensions are very high on a daily basis because we're debating very polarizing issues. And it is the people's house. I don't know what the rationale is. We've heard every argument from, it costs a lot to have metal detectors and wands and extra security. And, I'm a lawmaker that will tell you when we want to prioritize something, we find money. We just do. I know it firsthand. And so I don't see a real reason why firearms should be allowed at all. And, you look across the street, City Hall, you cannot have firearms. You look all around, the state capitol, and there are places that we as a society understand that firearms really have no place. But unfortunately, to this day, any individual can have a deadly weapon as long as it's in their bag, their purse, their coat, their pocket. And those deadly weapons can still be used to inflict real pain, real damage, real violence upon the individuals that are in that Capitol building. Not just lawmakers, but, our staffs, the tour guides, everyone.
A lot of children, school children visit the Capitol now because of the armed people that came in, and you said April 2020, I think it was during the pandemic. There weren't probably children visiting, but on any normal day, there's buses outside the Capitol building every single day of the week for school tours. And so you just think about that's just a fraction of the people in the building. So I wanted to ask you, when the armed men and women came into the Capitol building in 2020, were you there working?
Yes.
That day?
Yeah, absolutely. We're not like, the House and Senate on the national level, which we have, private tunnels that we can walk from our offices to the Capitol. So, when I walked into the Capitol that day, I was met with, Confederate flags and an angry yelling mob and, signs like swastikas and nooses. And there was some level of calm knowing that once we got into the building, things would be okay. But there was a decision made to let that angry mob into our state Capitol building. And there's nothing like it. Even when we were watching the images earlier this month at the US Capitol, many of the lawmakers, we were calling and texting each other, just thinking to ourselves, we're reliving this. And it could have been a lot worse. If you look at those images, there was, just a thin line of law enforcement that stood between that mob that was right outside the House chambers and our actual seats. And so, the level of fear, you can't describe it. And the fact that to this day, that state Capitol building, we're still vulnerable. Every time we walk in to do our job, to vote on behalf of people, there is a possibility of violence due to the lack of security measures and the fact we still allow firearms.
I have a question for you. One of the things that I read in the paper, and I don't know if this is, what's being legitimately discussed, is this is an infringement on the Second Amendment. So I'll hear these quotes or on TV or read them in the paper. And I always, Kurt and I always sort of scratch our heads because our rights there's always restrictions on every single constitutional right. First Amendment, Sixth Amendment, Fifth Amendment, you name it, there are reasonable restrictions on them. Is that a legitimate viewpoint by legislators that this restriction would somehow infringe a constitutional right, or is it just people kind of sounding off in the paper?
I think it depends on the legislator you ask. I think that we're balancing a number of rights. We're balancing First Amendment rights, right? We're balancing Second Amendment rights. And then some of us are arguing that we also have the right to a safe workplace, one that you can actually do your job. And workplace safety, we've been talking about whether it is around firearms or mandatory mask, wearing for legislators. There is a sense that we should be able to go into our workplace, right? As well as the custodians and painters that go into that place, knowing that they will be able to make it home alive. That feels reasonable.
Oh, I'm sorry. So I think I saw last week on the news that Speaker Pelosi, I think this fine is as steep as $5,000 or $10,000 each time somebody's seen without their mask. Would you support a similar move at the state level? I don't know that it would actually happen, but would you support a move like that here in Michigan?
For me, I always look at things with an equity lens, right? So, for example, while I would want every single person to wear a mask and we have to make sure we're keeping each other safe, there is equity that needs to be embedded in that, right? Some people cannot afford one. Some people literally are and I'm not talking about folks that are just in the Capitol building. We provide PPE for every single person. But I think we always need to look at those things with an equity lens to find out who has access and then also who has the ability to pay those types of hefty fines.
And I think those were specifically for members of Congress, though, those fines that I saw. So, because I know that there's some people who were hunkered down who ultimately tested positive because they were near people who were not wearing masks during that incursion.
That's so selfish. That is just so selfish that people got other people sick because they refused to wear a mask. And it had to have been terrifying, Representative Anthony, to have to work under those conditions and then still have the threat exist out there. And one of the things too, which I know is 2020, even with the shutdown, had a record high number of mass shootings. So, for us to think that this doesn't happen with handguns or in our country, I mean, we know it happened during, with time where we were all supposed to be predominantly at home. I mean, it's really frightening.
Right.
So, Representative Anthony, what should we do next regarding the issue of weapons in our state capitol?
Well, one, 13 months ago, I introduced a resolution to classify domestic terrorism as a federal crime. And the very first bill that I introduced this term last week was the same resolution. We have to address these issues as domestic terrorism. We can no longer coddle. We can no longer use kid gloves. We have to call the thing the thing. And so I think that once we start to address this as actual terrorism in state capitol buildings and corners all across the country, I think we will truly start to address these issues. And then also we need to continue to advocate for a full ban on firearms in the Capitol building. It's a small step.
Thank you, Representative Anthony, so much for being with us today.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC.
Thank you for watching In the Name of the Law. We'll see you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.